Okay, welcome to today's webinar on corporate estate planning. Just kind of as a background on corporate estate planning, or before on the webinar, remember that today's presentation and materials are copyrighted by my office. Also remember that they're available for free to view at any time through my website. So no need to record this because you can go to the website and watch it anytime. Again, today's webinar is informational, and we hope you find it interesting and applicable to what you are doing. But remember that everybody's particular situations are different. So if you have any specific questions, you can either ask them here for general answers, or give the office a call, and we're able to go over your particular situation. And today's webinar is strictly for informational and educational purposes. You've heard all that before. This is my background. Again, stuff you've heard all before. Just you can read through that if you're new to the webinars and you haven't seen this before. Some more of my background. You can tell we're in a hurry today. What our office provides, we do a lot of entity formation and asset protection, and that's some of the stuff we're going to talk about today. We're also do some estate planning, title and escrow, business and real estate transactional documents, and of course our live education and free webinars. Okay, today's agenda for corporate estate planning. Overview of asset protection and estate planning. Then we'll talk about voluntary transfers of interest and involuntary transfers of interest. Here's an overview on kind of why we're even doing the webinar that we're doing today. Most of my clients are very motivated to protect their assets. Most of my clients have a large number of either real estate holdings or other assets that they're trying to protect, and that generally is the priority for most of my clients. For good asset protection, of course, I could speak for hours on what it really means to protect your assets. But as we're kind of doing this today, the key thing to remember today for asset protection is you want a good solid entity. That's going to be an LLC or a good partnership. And you want at least 2 members or partners involved. And that is because of that charging order protection that we've very often talk about. We do have many clients with single member LLCs, and we're going to kind of bring that in a little bit. But remember, the single member LLC just doesn't get that charging order protection to protect the assets inside the company from outside issues like lawsuits and bankruptcies, etc. So for asset protection, you want your LLC, we'll just use LLCs, or partnership by analogy. You want your LLC to have at least 2 members. And in fact, the more, the better. The more members, the stronger that charging order protection really becomes. And the more solidly your assets inside the LLC, like your rental properties, are protected. So any partnership that you create, because again, a partnership has to have at least 2 people by definition. So any partnership is going to have at least 2 people, or multi-member LLC. That's what you're kind of looking for. Now, estate planning, and most of my clients do look into estate planning and want to prepare for estate planning. And if you went to a typical estate planning attorney, what they would probably just tell you is they would set up your family trust, and then they would move all of your assets inside the trust. Now, this is great for estate planning purposes, and it's great for the allocation of your assets upon your death. It eliminates probate, and it can make things very, very quick and easy to deal with upon your death. But the problem is your living trust, this family living trust that you have, does not provide any asset protection. And if you were to move your LLC that holds your rental properties, for example, into your family trust, that LLC suddenly becomes a single member LLC, which loses its charging order protection and protecting the assets inside the LLC. So it's not recommended to move everything into your family living trust. And in fact, there are things we can do with your LLC or your partnership to take this into consideration, to work around this problem, because this has always kind of been a problem. You want to keep your LLC sort of with all these different members involved, so you get this great protection. But then what happens if you die? You want to make sure that those assets are able to be controlled by your family trust or your estate plan or whatever it is. And you want to plan for the eventuality that you might die while owning these assets, but you don't want it in the family trust. So that's really what we're talking about today, is what can we do with our companies to prepare for things going wrong with members or managers, and how to plan for the future, taking into account both asset protection and estate planning considerations. Like I said earlier, most clients really, their focus is asset protection. They are utilizing these assets for investment purposes. They're actively engaged in the rental property or the flips or whatever they're doing. And so these are sort of a business that they are currently engaged in, that they need access to these assets and need to be able to use these assets. So the LLC is still the preferred method to hold all of these. But of course, things do happen. Accidents happen, and people get sick, and people can die even at very early ages. So we wanted to be able to discuss how our clients can prepare for that while still maintaining and controlling their LLCs. Okay, voluntary transfers. What's a voluntary transfer, first off? Voluntary transfer is when a member of the LLC or a partner in a partnership decides that they want to sell off voluntarily their membership interest. Okay, so these are voluntary transfers, and these are actually much easier to deal with if one of the members, in not dying at this point, but just decides, I no longer want to be part of this, and I want out. The first thing you do, and some of the rules, we're going to go through married partners. We're going to go with unmarried but related family members, and then we're going to go through unrelated partners, so sort of true partners that are not family, not related. Because some of the considerations are a little bit different. You have to remember that if you're married, there are legal rights to what is owned jointly by the marriage. And by the mere fact that a company was started during a marriage, and even if, just let's say, the wife is the sole member of that LLC, the husband still has rights to that LLC and its assets by definition of marriage. These are sort of the legalities of marriage allow this kind of thing to happen. So as we talk about this, these ones that are starred, these actually apply to pretty much all across the board, not just to married partners. So these are sort of general considerations that you need to kind of always remember when talking about transferring this membership to somebody else. You first need to confirm your own documents as to what process is required to transfer your ownership. This will be found in your operating agreement. Okay, in the documents that I create, if you had my office create your operating agreement, the standard is that membership interests are not allowed to be transferred without amending the operating agreement. Now this is a little bit of a harsh rule that I put in there, and I do it on purpose. With married partners, maybe that's not a concern. But there are some asset protection reasons why that is true, and some managerial reasons why I do this. So right as of now, if I did your operating agreement, then you cannot transfer your ownership without amendment. Now, it's very easy to do amendment. It just requires the signatures of all the other members. So everyone has to sort of approve the change. And it's certainly very easily done if, for example, in mortgage counting rules. Most of you are probably now aware that if you have ownership in a property that has a mortgage on it, that mortgage will count towards your maximum number of mortgages you can have, even if that mortgage is not in your name. So if a husband and wife own an LLC and they have 10 properties, And all 10 of those mortgages are in the husband's name. And then the wife goes to get a mortgage in her name. And when she goes out to fill out paperwork, she will have to list every property that she has ownership in that has a mortgage on it. So she has to list all 10 of those properties, even though the mortgage is not in her name. So what we've been doing is we've been taking the wife off of the LLC, so she now has no ownership in those 10 properties. We set up a new LLC for her. She can then go out and get her 10 properties with mortgages in her name. And then once she's maxed out, then we combine them back and put both spouses back on ownership on both those LLCs. So in that sense, we are changing ownership of LLCs. And so we just create an amendment. Both husband and wife sign it. Husband transfers his 50% over to wife, or wife to husband. And that's how we transfer back and forth. And so we can do that very, very easily to accommodate that. And we know in that interim that we're losing some asset protection because we don't have that multi-member LLC. But the reason is to get mortgages. And so, again, we have to balance things sometimes. And that's why we always say there's no one size fits all around here. Everybody's situation is different. So remember that how you own and who owns these entities, it will count towards your mortgages. Management and percentage interest. I have pretty much always create LLCs that are managed by managers, not by the members. That is a big difference, and it makes a big difference when we're talking about transferring interests to other people. And in the event that one of the members is sued and that charging order protection kicks in, the LLC is much stronger by having it managed by a manager, because then that manager, who's probably the other partner who didn't get into trouble, can continue to control the company without say from that new creditor that has stepped into the shoes of the partner that got sued. And again, if that's a little confusing, I understand that that's the whole charging order protection thing, and there's plenty of videos on the website discussing asset protection and liability and charging order protection. So that's why I always do management of the company as by the managers, not the members. If it were the members, then anytime a member died or was sued or went bankrupt, you're bringing a third person into your company as that member with some rights, but as long as it's managed by the managers, they don't have the rights of management. They just sort of are equity partners. They get money and no control. And percentage interests, everyone, especially husband and wives, love to do 50-50, which is great. And husband and wives, I have no issues with doing 50-50. Even partnerships, they always want to do 50-50. But remember, if there's 50-50, if there are issues between the two members or more, if it's equal, it becomes very difficult to make changes because both have to agree. So very often it can be preferable for one member to have 51% and the other one 49%. That can make things a little bit easier down the road. But typically we do 50-50, and that's fine. Dual managers. That is if you name more than one person as the manager. So we know that we're always talking here about multi-member LLCs, and these LLCs are managed by managers. And then you have to list who those managers are. Having dual managers, the good thing is there's a check and balances that goes on between the two managers because the two managers have to agree on things. And no single manager can do something without the other one's permission. The bad thing is at title closings, both managers will have to show up. Because both managers need to sign on behalf of the company. And that's the way my agreements are written, which is why if you, again, had me do your documents, you have an extra document in your binder of information called a single manager authorization form. This is a very important document. If you don't have one, if I didn't set up your LLC for you, you can certainly call the office and just ask for it. Essentially, it's a document that states the name of the LLC, who the two managers are, that the two managers discussed and authorized one of them to buy or sell a particular piece of property. And that way you can take that document into your title company and only one of you needs to sign at closing. But again, both are there initially in the decision to do that. So that is something to kind of be aware of in these, when you're talking about manager-managed LLCs. How many managers do you want? And what kind of control do you want them to have? And as you see when we talk about death of a member or other kind of involuntary transfers, that manager is really going to be the one controlling everything. And if, let's say it's a husband and wife, let's say it's two partners, partner A and partner B, and they're both also managers. If partner B dies, then partner B's membership can go somewhere else. But managerial responsibility does not transfer with death. And so partner A remains completely in control 100% as the only manager. So think about that as you are deciding, who's going to be manager, et cetera. And then finally, with married partners, and the kind of general ideas we're talking about here is transferring back and forth between married partners, husband and wife, spouses, usually raises no accounting issues, especially if they file jointly. Then we can transfer back and forth, and you never have to worry about it being a taxable event or something like that. So it's very easy to do. Okay, non-married family partners. Now, again, remember all the general things we just talked about, but first, before you transfer any kind of membership interest, confirm with your accountant whether or not that transfer will be a taxable event. Because let's say this LLC owns a property, it's worth $100,000 net equity, and then you want to transfer your 50% ownership to somebody else, to a son. You've just given away $50,000 to your son. That's actually a taxable event. And so when you're talking about transferring to others, just make sure that if it's not someone you're legally wed to check with your accountant about whether or not this will be a taxable event, and it's going to depend on net equity and other things, and basis and all of that stuff. The note there on gifts to children. Remember, you can gift to your children ownership of LLCs that own property. And this is a way of transferring ownership to your children tax-free. You can do, I don't remember the exact number, I think it's $17,000, it changes every year, about $17,000 to each child, tax-free each year. So if you want to give a home, even if it's, let's say, a family cabin, and you want to leave it to children, you want to leave it tax-free, you can gift it little by little to your children by giving them a little bit of ownership in the LLC that owns the property over time. So again, that's a great way to transfer ownership in real estate or in property or any other asset to someone else. It can be tax-free, but it is a way to sort of prepare for the eventuality of you dying and what you do with your estate and how you transfer property about, at that point. So if some of you are interested in that, just maybe have a conversation with your accountant and come talk to me, and I will work with your accountant to make sure that we transfer the right amount of ownership in the company to children little by little over time. Unrelated partners. So this is when you've got an LLC with two people who are probably not in the same family, okay? In this situation, you definitely want a buy-sell agreement. This is an additional agreement that can be added on to kind of like an addendum to your operating agreement. And what it does is it really defines out what happens if one of the partners wants to sell or voluntarily transfer his membership to somebody else. And these are contracts, so they're very customizable. We can kind of create them to suit your needs of however you want to create this. But generally, these buy-sell agreements have what's called a right of first refusal in them, which means when partner B decides he wants out and wants to sell his ownership in the LLC, he must first present his membership offer his membership for purchase to partner A, who has the opportunity to buy his partner out. And the reason you want this is you don't want your partner selling off his membership to somebody you don't know or don't like or don't want to do business with. So this is a way of controlling who has access and rights and membership to this company, which is, again, another reason why my standard operating agreement always prohibits transfer except by amending the operating agreement, which requires both parties to sign. So again, this is a way of controlling who are the owners and therefore who are the managers of the company. The buy-sell agreement will also usually give a time frame, like provide 30 days notice. The partner A has 30 days to decide. It'll talk about how the membership interest is to be valued, fair market value, appraisal if it's real estate, these sort of things, so that you can come to terms of what your partner's membership is actually worth. And it'll talk about closing, of how money is to happen and change hands, and how the rights go back and forth. So the buy-sell agreement is really a critical document if you're working with unrelated partners. It is definitely also recommended if you've got family members who you're not married to, maybe a father, uncles, brothers. So just going to be aware of that. Okay, so that's unrelated partners and the buy-sell agreement. We'll talk about the buy-sell agreement does more than just this. But again, we're talking about voluntary transfers when the members themselves choose to somehow sell or get rid of or transfer their membership interest. Okay, the next section we're going to talk about involuntary transfers. Now, an involuntary transfer, there's a list here. Divorce. I struggled where to put divorce. I didn't know if, because divorce is a decision. So technically it is a voluntary, transfer, because it's you choose to get a divorce. But it usually is a choice that people don't want to make, or make it as a last resort. So it kind of becomes involuntary. You're getting a divorce. Okay, now what do you do? Okay, incompetence. This is also very important. If your partner becomes incompetent and there are decisions that need to be made, and especially what if this partner or member of the LLC is also a manager? So you may want to think about, that eventuality. And here we have reasons of what we'll do, but I'm just going through the different kinds of involuntary transfers. Court order. This is if your partner is sued. If your partner is sued and you've got this multi-member LLC or a partnership, then the court actually steps in and can take over your partner's membership interest. And we'll talk about how that happens. Bankruptcy, again, very similar. If someone files for bankruptcy, then the trustee in bankruptcy steps into that partner's membership. And then, of course, death. And that's a big one. So what do you do in these situations of involuntary transfers? Well, divorce. There's a post-nuptial agreement. It's kind of like a prenup, but it, of course, comes after the fact. I know most clients don't want to think about divorce, but you probably should, and what would happen in a divorce. And we can create, and I usually create these with a family law attorney, because that's not my background, I'm corporate. So we work with a family law attorney to create an agreement that can dictate what you want to have happen in the event of a divorce. So let's say husband and wife own the LLC, they decide to get a divorce, but maybe husband does all the work and has been managing these properties and put up his own money through, let's say, some money he inherited from his father. So there's an agreement that most of that property is to go to the husband, okay? In Utah, Utah's not a common property state. So it's not an automatic 50-50 division upon divorce. It is an equitable distribution, which means that husband and wife each present their sides to the judge, and the judge makes a decision on what is equitable if they can't agree. But this this agreement that they sign in advance can go a long way in dictating what is to happen. Because once the divorce kind of becomes imminent, it's just my experience that communication breaks down, people stop talking, partners get angry, and it's very difficult to get sort of any agreement reached. And so having this agreement in advance can really go a long way. And so that's a way of dealing with divorce. Incompetence, power of attorney. You should always have a power of attorney on, a partner, particularly if that partner is a manager of the LLC, so that you can act on their behalf. They're super easy to create, and you can get them done very quickly. For court orders, this is if your partner is sued or in a bankruptcy. The charging order protection is really what you're relying on to protect yourself in these situations. But what happens is either the court or the creditors who are suing your partner, or the trustee in bankruptcy if he's filed for bankruptcy, will get what's called a charging order against that person's membership interest. And the way all of my documents are written, I really beef up this protection in the operating agreement, that the trustee or the court or the creditors only have ownership rights and rights to income streams. They don't get any voting rights. They don't get any managerial rights. And that's it. So no vote, no management. The only thing they get is that partner's share of distributions when distributions are made. And as long as the properties have been sitting in that LLC at least a couple of years before any of this happens, they're pretty solidly in there. For new assets that are transferred into this LLC or partnership, trustees and bankruptcies can go back a year or more and pull things back out if they think that it was a fraudulent transfer. So again, just another word of reminder to always make sure you change title to your properties into the name of your LLCs very, very quickly. Because the longer they sit in there, the more protected they are. Now, death. What happens when you die? And this is kind of a big part of our big discussion for both when you're talking about married partners, unmarried partners, and unrelated people. Now remember, for most married people, their goal is that their estate plan, their family trust, be able to control and manage all of the assets without going to probate, without going to a judge, and without dispute from the kids, the heirs. But like we said, we're probably not going to put the family living trust at owning these LLCs, because then we lose that great charging order protection. So what we generally do is create transfer on death agreements for each member that transfers upon their death their ownership to either the remaining spouse or to the couple's family living trust. And it just depends on what clients are looking to achieve and where they're at in their life and maybe how close to death they are, et cetera. So what this transfer on death agreement, also called a TOD agreement, it's a contract that stipulates upon the death of partner A, then partner A's membership interests will immediately transfer to, and then we list who it's going to transfer to. And all that is required is the presentation of the death certificate. So upon the presentation of a valid death certificate, then that member's ownership in the LLC can pass to whomever he or she would like. Most typically, it's going to be the remaining spouse or the family trust. So this is a great way to maintain the asset protection that you're looking for by having these multi-members in this LLC, but knowing that as members die, then ownership will slowly be transferred over to the family trust or the remaining spouse, who usually then leaves it to the family trust. And so highly recommended for most situations, if you have more than one member of your LLC, create a transfer on death agreement for the membership interest. Okay, now if you're working with unmarried family partners, brothers, sisters, dads, uncles, even kids, incompetence. The buy-sell agreement also covers incompetence. What happens if the member is adjudged by a judge, and it does take a judge's order with doctor's signatures, etc., that somebody has become incompetent, that the buy-sell agreement can actually kick in and dictate that the incompetent person's, it becomes an offer to sell to the remaining members. And that can be adjusted if that's not your stated goal, but that's the general occurrence under incompetency. And you can do, again, like I said, powers of attorney, which are very important, easily done. So having powers of attorney for members is great. And you can do what's called a specific power of attorney, which only allocates certain rights. So maybe it's only the right to vote on behalf of that member in the LLC, or to manage for that manager on behalf of the LLC. And it doesn't have to necessarily go to the other partner. It can go to another family member or somebody else, a trusted advisor, etc. Again, for court orders and bankruptcies, again, that charge order protection is really what you're relying on in those situations. And death, again, you can use a transfer on death agreement. Now, kind of word here that the transfer on death agreement will transfer ownership of this property, and it will be just like the estate of that person transferred it to somebody else. So it is possible that this becomes a taxable event. That will depend on the estate and the value of the estate of the person who died. But it does sort of become a transfer within the estate. So just going to be aware of that. It's not necessarily a tax-free thing. It is subject to estate taxes, if estate taxes apply. But again, you can easily get these TOD agreements with unmarried family partners. And unrelated partners. Again, the buy-sell agreement, absolutely crucial here. And it covers all involuntary transfers, which become essentially offers to sell under a right of first refusal to the remaining member. The buy-sell agreement also covers death, and it is a life insurance buyout. So how this works is each member carries a life insurance policy on the other member. And the reason why you carry the life insurance policy on somebody else is because if that other person dies, that insurance policy kicks in and cashes out the decedent's estate from their ownership in your LLC. So in other words, when he dies, the estate gets paid off, they leave, and you get 100% of the company. So it's a way of buying out the estate without you having to come up with any cash. So without a buy-sell agreement and this life insurance policy, if your partner were to die, then their estate would come in and take over in their place. And so now you've got a partner with a spouse of somebody that you didn't like the spouse, or their kids or their parents or whoever their heirs are suddenly now your partners. And so you want to buy them out to get rid of them, but you don't have the cash. Well, that's what this life insurance policy does. It is a life insurance policy that kicks in and buys out your partner in the event of their death. Fantastic way to control what happens to ownership of this company in that eventuality. And these life insurance policies are very, very cheap. It's based on that partner's value of the company, and you should reevaluate that each year as the company grows or its assets, appreciate. And then each year you can kind of just reevaluate the total value, split it up by percentage ownership, and then just tell your insurance agent, here's the value of the life insurance policy you want to carry on the other person. And again, you carry it on the other person because you want to make the premium payments. Because if he's carrying it on himself, if he misses a premium payment, then he's got no life insurance policy to pay off his estate, and you're stuck with his estate. So you carry insurance on the other person, and that way you know the premiums are being made, and if he dies, that insurance policy can kick in and buy his estate out. So again, the big takeaways from today's sort of planning is be prepared. You can discuss divorce with your partner and discuss what you want to have happen in the eventuality of divorce. And that is a bit of a sticky thing because marriage comes with legal rights to property. And so generally it would just go to court and they would divide it up equitably. But if there's something else that you want to have happen and you want to do in advance, look into that. Look into these buy-sell agreements, which can control the process of what happens in these involuntary and voluntary transfers. And transfer on death agreements. These are fantastic. I recommend all clients sort of add them on to their operating agreements. And then again, if you do the buy-sell agreement, highly recommend life insurance. You can do a buy-sell agreement and not pay for the life insurance. You can do that too. But again, if there's no life insurance, then there's no cash to buy out the estate. But you can still get the other benefits of the buy-sell agreement and controlling the process and controlling who has access to it and the rights of first refusal without the life insurance. Okay, I will open up to questions for our next few minutes while I'm talking about our next webinars coming up. Wednesday, October 15th, that's next Wednesday from 7 to 8 p.m. at night. I'm actually teaching a webinar, how to start a real estate business. I am doing this with the guys from Avenue A. And so you'll have to look at my emails to get the link to that. I don't know if that's on my website right now. And then of course, the next Tuesday webinar at noon is family trusts, wills, power of attorney, and healthcare directives. This is, again, kind of a logical next step of once you kind of decide what you want to have happen with your company and its membership and the ownership of the company and those assets, the next step is, where do you want it to go? Do you want to go to a family trust, to the will, et cetera? So next Tuesday, we're going to be talking about setting up family living trusts and the ancillary documents to that, what's called a pour-over will, powers of attorney, and healthcare directive. So that's coming up in a month. Okay, so far no questions. Okay, no questions, so I will end today's webinar. Feel free to, obviously, you can always email me or call the office, 801-560-2180, and ask specific questions to me or my staff. So again, hope you have a great day. Go on and make lots of money, and we'll talk to you soon. Thanks.